Hello, I'm Wesley Timothy, Senior Underwriter at Dual Asset, and I've experience in this industry since the beginning of 2007. I've underwritten cases from resi to high value commercial, covering a vast plethora of risks from building regulations, chancel repairs, easements to village green. However, I am particularly known by my peers for my love of water and drainage law, somebody has to, which stems from my early career in the water industry. Welcome to this first session in a series on restrictive covenants, where I will be discussing the use of legal indemnities insurance in the real estate transaction. I will give you an insight into the thought processes of an underwriter, letting you know the information we need to assess in order to package and offer cover. Cover is available on a continued use basis and also on a development basis. As an industry standard, the cover will operate in perpetuity and benefit the purchaser, their lender, tenants and occupiers. This also means that the seller has a fuss-free, clean exit. Though do query with that with your underwriter if that is not clear. This session is intended to be a basic overview, so it is aimed at brokers, lawyers or conveyancers with little experience in the area, though anyone who wants a refresher is more than welcome to stay with us. I'll also be telling you about some of the claims that we have received and how we have dealt with them. By the end, you'll have the confidence in identifying when you can utilise insurance as a risk management tool to ensure that the end user can purchase or invest with peace of mind. Starting this series with a high-level overview as to why, where, when, who, what and how restrictive covenants burden real estate and can be covered by insurance. The areas I'm covering here deserve a much more detailed assessment, so forgive me where I pay lip service. The pertinent points will have sessions dedicated to them in the future. The law relating to restrictive covenants is huge and it continues to grow. As we know, the law is a reflection of the needs and demands of the modern day. Whether it meets them is a topic for another day. In these interesting times where property prices are spiralling, vacant land has also become much more valuable because of its potential to provide for our housing and economic needs. The government has tasked local authorities with providing for this, so laws relating to village green registration slacken, for example, and the grant of plan permission is seen more and more as a positive reason to modify restrictive covenants. Covenants are the bread and butter of the legal indemnity underwriter, being a risk that most of us cut our teeth on. They are full of all the ingredients making up the steep learning curve of assessing real estate legal ownership issues. So what are they? They are a promise made between two parties, a seller and a purchaser typically, not to do something with the land, which can also apply to and burden future owners of the property. This will range from what is built on the land, height for example, to how that land is used, i.e. not as a pig farm or tyre burning facility, for example. Fundamentally, restrictive covenants are a means of protecting property, both in terms of the aesthetics of a neighbourhood and, most importantly, value. Though we can also see that they have been used by unscrupulous former landowners to extract ransoms from developers, may seem a rather cynical viewpoint, but it is born from experience. But in most cases, action will be about homeowners protecting where they live, and particularly their property value. We love wherever we settle generally, and as human beings find change, disruption, uncomfortable. Our species can also be rather stubborn. Whereas most claims are dealt with by negotiation and settlement, there will always be cases where money is not the object and the principle is king. Covenants and covenant breaches are so commonplace that offering cover in the distant past may have been viewed generally as run-of-the-mill, but now we live in a much more litigious society. I have on occasion been guilty of reviewing a case and believing there to be little chance of a claim being made, only to have egg on my face a few months later, though claims are very important and welcomed in our industry. As I often say to underwriters, it is near impossible to underwrite the myriad personalities of the parties involved. We mustn't be blasé about restrictive covenants. even though we can see from recent developing case law that most covenants are easily capable of modification. The cost of doing so will be eye-watering. Taking a case to the upper chamber of the Lands Tribunal is very unattractive for the developer, both in terms of time and cost, but these issues are inherently a form of neighbour dispute where reason takes a holiday, requiring the certainty of a decision from the courts in order to realise the intended investment. Though do always bear in mind that a mere application does not guarantee success, the tribunal's decision is discretionary. Though facts may have a strong resemblance to a case that has been before, it doesn't mean the same answer will result. Modification of covenants under Section 84 of the Law of Property Act will be subject of a further session. So, getting back to our original questions when considering taking an insurance policy, why seek the cover? Purchasers and/or their lenders want to buy a property that has restrictive covenants noted on the title, which might prevent them from using it as they wish, meaning that the property is at risk of a drop in market value, or the owner is exposed to hefty legal fees and settlement costs at some future date. Removing this risk maintains the market value of the property and enables the owner to deal with it as though the issue does not exist. Lenders and investors are more likely to be on board. The financial liabilities stemming from the covenant are covered by the policy. And where has the need for cover been identified? Well, during the conveyancing due diligence, restrictive covenants would have been noted in the charges register of the office copy entry for the property, where we're considering registered land, that is. There would be no apparent evidence of a release of those covenants, and, where relevant, a Type D2 land charges register search may have revealed a positive result. More on those in the course materials. Meaning that the incoming purchaser has noticed that the property is so burdened. When did the issue first come about? The covenant would have been imposed at the point where the property was sold and broken out of a larger parcel of land. The original vendor would have imposed the covenant and the original purchaser agreed to it in order to protect the value and amenity of the retained land. Who can cause a problem? Check what the covenant says about the beneficiary. Also, which surrounding properties benefit and will be impacted by our breach. We need to ascertain whether the rules of annexation apply, and there'll be another session devoted to this separately. It may be that we can determine that the covenants do not meet the legal criteria established in the legendary Crest-Nicholson Court of Appeal case of 2004, and I'll provide that list in the materials too, which will be explored in the future, and have lost their teeth. It's important to remember that not appearing to be legally enforceable doesn't necessarily mean a third party won't try to enforce, or that the court won't attribute some value to the covenant. See Reed Perkins' application of 2012 for an example of that. What can a third party do to bring about a claim? The possible first step is to threaten injunctive action, requiring that our property ceases to be developed or is put back to its original form where development has already occurred. They would need to establish that the land has the benefit of the covenant and that the breach has a substantial impact on the value and amenity of that land. In most cases, they are more likely to accept damages instead, accepting a settlement fee and some other form of remedial action. How much? The most important question when assessing the availability of coverage, and something that you must consider in order to ensure that the end user is sufficiently protected. In the event of a claim, will the property become a write-off, to borrow the vernacular of another insurance industry? In the event of a claim, however unlikely, how much will it cost to put things right? If outside of the court, it may be that surveyors can agree on an adequate sum, though we have seen in our mediation that surveyors on opposing sides might butt heads rather fiercely. If the breach is so great and outside the spirit of the covenant that an injunction is likely to be granted by the court, we'd be looking at the costs associated with reverting the property back to a form in compliance with those covenants, plus any associated drop in market value. We must not forget the legal costs, especially where the matter gets to court. These could dwarf any other relevant figure. If we think an injunction is near impossible, backed by a robust legal opinion, how much is a third party likely to accept as a settlement? Are they the only party? Is there a contagion risk here? Never forget to factor in legal costs, which are covered under our policy coverage, separate to the policy amount. Speaking of claims, how about a couple of claims we have dealt with under our policy coverage? Both available via our website. The first, a sneaky covenant holder. A policy was taken out to build a new home at the rear of an existing one in the back garden. This breached the restrictive covenants burdening the land. Planning was granted without objections, something that we do utilise as part of our processes, engaging the feelings of the neighbours and how the proposals are likely to be received. When marketed, the neighbouring covenant holder objected on the grounds of covenants. Council had advised us that the covenant was indeed enforceable. During negotiations, it emerged that the motive was wanting to buy it and build a new downsized home for themselves, and they used the covenant as leverage for a discounted price. We compensated the policyholder for the discounted sum, using the market price another party would have paid. Covenant claim deals with some 1980s density covenants in favour of the local council, which was breached when constructing 8 flats to replace one dwelling. During the course of developing, an access to the public car park was disrupted and drew the attention of the legal team at the council. Covenants were spotted and injunction threatened. The covenants were enforceable and an injunction a possibility. This was confirmation to us that the grant of planning is entirely separate to agreement to discharge private legal rights. We negotiated damages with the council, so injunction was off the table, and after a rather princely sum was demanded, we agreed a more suitable settlement, which we paid in addition to the associated legal fees. Welcome to the next in this series of restrictive covenant sessions. Here we'll be following the historic division of a parcel of land and determine which individuals have the ability to enforce covenants against one another. In particular, where the extent of the benefiting or dominant land is not immediately obvious from the reading of the conveyance or transfer, is it possible to easily ascertain that area by looking at surrounding circumstances, a la Crest-Nicholson of 2004. When embarking on the career of an underwriter, assessing your first restrictive covenant cases can be a little daunting, whether you are au fait with the legal principles or not. This is a session I like to run early with new underwriters to encourage breaking down a puzzle into individual pieces so these can be reassembled into one picture with greater understanding of those parts. This session is intended to be a basic overview, so it is aimed at brokers, lawyers or conveyancers with little experience in the area, though anyone who wants a refresher is more than welcome to stay with us. By the end, you'll have confidence in identifying when you can utilise insurance as a risk management tool to ensure that the end user can purchase or invest with peace of mind. You will have a greater understanding as to how large parcels of land can be divided up, looking substantially different, if not unrecognisable, yet still riddled with legally enforceable restrictive covenants. Restrictive covenant insurance cover is available on a continued use basis and also on a development basis. As an industry standard, the cover will operate in perpetuity and benefit the purchaser, their lender, tenants and occupiers. This also means that the seller has a fuss-free, clean exit. Though do query that with your underwriter if it is not clear. And so on with the substance of this video. The key components for determining whether a restrictive covenant is bound to land are set out in the Crest-Nicholson Court of Appeal case from 2004. It must be negative in nature as opposed to positive, requiring that an activity is not carried out. It must be intended to benefit identifiable dominant land. It must adhere to the notice rules in terms of being sufficiently discoverable on the charges register and/or noted in a type D2 land charges search. We touched on the latter in the first session of this series. It must be intended to bind successors in title. The wording of the covenanting clause needs to be relatively clear as to who is burdened by the restriction and how it is envisaged to run with the land. For our purposes today, the wording of the covenants is not the focus. These have been perfectly constructed and expertly drafted by the lawyers involved. They have been correctly recorded at Her Majesty's Land Registry, and there is no question whether successors in title abound. We are asking ourselves who is legally capable of enforcing them. In our experience, a multitude of parties are capable of lodging challenges, but who will the courts agree has a case for retaining the benefit of those covenants? I've often likened underwriting to carrying out an investigation to solve a mystery. So let's don our deerstalkers and reach for our magnifying glasses. We find ourselves in the 1950s. Lord Black inherits the family estate, Blackacres, from his late father. Our protagonist's only sibling perished in the same accident, and his mother did a runner with a groundskeeper yonks ago. His only remaining relative is his niece, Lady Scarlet, and mourn her later. The entirety of Blackacres is already registered at Her Majesty's Land Registry. After years of lavish parties and unsavoury recreational habits, Lord Black's funds are looking bleak. Dame Peacock, local philanthropist, entrepreneur and prima donna, seizes the opportunity. She offers to boost the Blackacre coffers by purchasing part of the estate. Black transfers title to the south to Dame Peacock. Though being aware of her charitable nature and love of cats, Black is keen to protect the values of his estate, so imposes some covenants. 1. No more than 4 private dwelling houses. 2. No businesses. 3. Nothing to cause a nuisance to the remainder of Blackacres. At one of Black's further soirees, arch-rival Professor Plum expresses interest in purchasing part of Peacock's acquisition. He wants to house his scientists nearby, his revolutionary top-secret project. Dame Peacock has not been using the land particularly, and in fact maintaining it has been quite demanding. Though she feels there's something odd about Plum, she seeks to sell it but protect herself to make sure he cannot build more than 2 private dwelling houses. This means that her remaining portion is still capable of being developed as at least 2 properties. If Plum breaches those covenants, it will have an impact on the value of her remaining land. Meanwhile, neighbour Colonel Mustard has been looking longingly at the game birds frolicking in Blackacres. Colonel Mustard, who is also Black's godfather and a great friend of the late Lord Black, both used to hunt in those woods. Knowing that Black is in need of some capital, and in order to relive some of his former glory days, he offers to purchase the woodland. It takes a fair amount of negotiation, but Colonel Mustard purchased the land subject to restrictive covenants benefiting the remainder of Blackacres. That the woodland would only be used for hunting and fishing, and not to construct any permanent structures of any kind. The latter because Black has always enjoyed the privacy from prying peepers that the estate provides. Having heard that Black sold the land for recreational purposes, Reverend Green expresses an interest in buying some land using parish funds to hold fetes, etc. During the 1970s, Black's coffers are drying up again. He is reluctant to sell to Green, as to do so would mean the peasantry getting too close and potentially having easier access, but the money sings a sweeter song, and he sells the northern eastern part of the property, which Green will annex to the adjoining St Mary's Church. The parochial church council funds are somewhat limited, but Black doesn't want them to profit too much from the estate. A covenant is imposed that the subject land can only be used for charitable fundraising events. In addition, Black enjoys uninterrupted views of St Mary's, which his family built in the Middle Ages, not that they've ever been inside it, so he doesn't want any structures to spoil those views. Appreciating that temporary stages, toilets, etc. may be needed, an additional covenant is written in that any permanent structures erected should be limited to a single storey and no more than 4 metres in height. To sweeten the deal in his favour and to make up for the low purchase price, Black negotiated a separate agreement with Green and the parochial church council to claw back 50% of any money raised by the events held on the property. The events held by Green proved more successful than anyone could have imagined. Greenfest attracts thousands of paying guests and the biggest names in the music industry. The Black fortune is restored, though the parochial church council are peeved that most of the charitable money is going to the former landowner. We now find ourselves in the early 1980s. Black suffers a violent death, having fallen from the top of the stairs with a knife in his back and a rope round his neck. There is also evidence of blunt force trauma and a gunshot wound. The local constabulary suspect foul play. Lady Scarlett, Black's niece, inherits the remainder of Blackacre, including Manor Black itself. The nefarious Plum has been sniffing around for the past decade. He wants to buy the remainder of the estate. He has often been seen whispering to Scarlett at dinner parties. His experiments are proceeding well and he wants to expand the operation. Scarlett sells the lot and in her hasty departure to Monte Carlo imposes no restrictions on the use of the land. So now here we are. Plum is the owner of the land shown in 3 shades of purple. The reason I've done that is a bit of a clue for what comes next. Blackacres has been divided into 5 distinct titles. Plum's original purchase retains its original title number, though it is owned by 4 individuals. The Blacks no longer own property in this country. So, having digested and remembered all the details pertaining to the breaking up of Blackacres, let's run through some future scenarios. Dame Peacock has built one house that she lives in with her clouder of cats. She wants to construct another building to use as a cat sanctuary and kitty day spa. Can anyone stop her? As a reminder, the covenants that were imposed were 1. No more than 4 private dwelling houses, 2. No businesses, and 3. Nothing to cause a nuisance to the remainder of Blackacres. The answer? Everyone except the first area that Plum purchased. The latter is burdened by the same covenants. The former were all the retained land of Blackacres at the time of that transfer. Peacock is arguably breaching the second covenant with the proposed cat complex. It is not inconceivable that such use could also constitute a nuisance to the other neighbours. Well, if they were so minded, could put together a strong objection on that ground. Colonel Mustard wants to build a hunting lodge and introduce more exotic species to hunt. Who can stop him using covenants? As a reminder, the covenants in question are 1. Only to use the land for hunting and fishing. 2. No permanent structures of any kind. And the answer is Reverend Green and the parochial church council, and also Professor Plum, but only in relation to the darker purple area, which includes Manor Black. Green might be concerned about his guests being mauled by ferocious animals and would be required to install much stronger and expensive fencing for health and safety reasons. Plum may have the same concerns, and a hunting lodge may enable Mustard to see what he is up to in Manor Black. Peacock and Plum's original parcel was already out of the estate when these covenants were imposed. Unless it was an obvious building scheme, which it isn't, they do not have a legal ability to enforce these restrictive covenants. Reverend Green wants to retire to Monte Carlo. He wants to pilfer the Greenfest proceeds for himself. The parochial church council is now getting 100% of the income following Black's demise. And build a hotel. Aside from the parochial church council having something to say about it, who can prevent his development plans on the grounds of restrictive covenants? As a reminder, the covenants here are 1, that the land can only be used for charitable fundraising events, and 2, any permanent structures erected should be limited to a single storey and no more than 4 metres in height. The answer: Professor Plum, in respect of his interest in the darker purple land, which includes Manor Black. Use as a hotel would breach the charitable and fundraising restriction. It would also fall foul of the permanent structure requirement, and if the intention was to build this more than 4 metres high. Plum could injunct. It's not beyond the realms of possibility that either of these could be modified, but that is a subject for another day. So, we have charted how Blackacres has been broken up over many years and how many differing personalities now occupy the former estate. We have determined who is capable of enforcing covenants against one another. We know this to be the case legally. However, will that stop any of the characters causing a nuisance by demonstrating their knowledge of the existence of them? No. If considered at the tribunal, are the covenants capable of modification? And if so, will they be modified? What is the level of damages the injured parties will receive? Well, we don't know the answers to any of these questions with any degree of certainty. However, I'll have a try at responding to them in a further session. Well, thank you very much for joining me today, and I hope you've enjoyed listening to it. Please do have a look at the downloads at the bottom of this video, and I hope to see you on the next video. Thank you.